My name is Dan Cogdell. Anthony Oso and I are two of the lawyers that are helping Ken Paxton. You know, when you get ready for a case like this, there's some things that you know, and there's some things that you don't know. Well, in this case, when I was preparing, I knew I was going to know most of the lawyers. I know my opposing counsel, known them most of my life. They're friends. I'm not going to say anything negative about them. It should give you some pause, though, because if they're friends with me, you know their judgment is a little bit askew. That having been said, I know some of the witnesses. I know Mr. Penley. I know Mr. Maxwell. Most of these people are good people. I have no problem with their character, generally speaking. I have a big problem with some of the things that they did. I don't mind sharing with you that my wife is going through a significant medical issue. And wasn't the best time for me to come here. But she said, no, you go. This is bigger than me. This is bigger than you. And this is bigger than Ken Paxton. No offense, Ken. She's not your biggest fan. But what she meant by that is we are living on the wet end of democracy right now. Is it up to the voters or is it up to politicians to see who stays in office? Your decision is much bigger than Ken Paxton. Your decision is literally about democracy in this state. I appreciate Mr. Murr's comments. I also appreciate the focus on the bigger picture and what's happening in here. One of the things that's intimidating, even I've been doing this for a long time, 42 years. Sometimes I don't recognize that dude in the mirror when I walk in the mornings. But I wondered to myself, how do I begin a case like this? This is a case of enormous consequences. I wanted the press. I wanted the sound bites. I wanted the cute things, right? As a side note, this may be one moment I get to relish because I'm not automatically the biggest ego of the lawyers involved. Not automatically. I have some competition. The significance of this case is titanic, as I mentioned. And I wondered, what am I going to do? What am I going to say? Oh my God, I need the hook. I need the line. I need the pop. And it occurred to me, I don't need that. It occurred to me that I have the truth. It occurred to me that the reason we're here, how did we get here? This is the very room where General Paxton has been sworn in again and again. This is the very room, as I understand it, where one of his daughters got married. How do we go from that to here? I'll tell you how. Because people assumed things that weren't true. They assumed that Paxton was involved in an illegal relationship with Nate Paul. They assumed that Paxton's actions were intended to get the records to Nate Paul. They assumed that Paxton gave the DPS records to Nate Paul. They assumed that Paxton hired Kamek illegally. All of those things are false. All of those things are false. Even Einstein said assumptions are made and most assumptions are wrong. A man much lesser, perhaps, than Einstein, but it's important to me, my dad, he told me when I was a young kid, you know, son, you can't spell assume without making an ass out of you and me. And he's right. And that's exactly what happened in this case. The reality is, this is not a trial where you can assume anything. This is a trial that requires proof beyond a reasonable doubt. Spoiler alert, it's the same amount of proof that's required in a death penalty case. I'm a visual learner. I like to see things to help me learn. So I'm going to offer these next slides to you. They're not the law, but they're an explanation. We deal with different standards. A lot of you are lawyers. A lot of you know these things, but a lot of you have never dealt with proof beyond a reasonable doubt. So let me suggest probable cause. If probable cause were a house, probable cause might look like that. Probable cause is the same standard by which the House had to, quote, indict or return the articles of impeachment. That is the quantum of proof that was required. Preponderance of the evidence. That is the standard that Mr. Busby uses in his cases. Those are in 50 versus 50 and a half versus 40, any slight more, any little bit more. That's a preponderance. Clear and convincing evidence. That is the same quantum of proof that is required in a situation where CPS wants to take your child away. Proof beyond a reasonable doubt, if it was a house, it would look like that. It would look like Mr. DeGuerin's house. It would look like a big house. Sorry, Dick. My point is a pretty simple one. There is a huge difference between the quantum of proof that the House based its decision on and what you are required by law to base your decision on. It's night and day. I'm going to go through the articles quickly. Judge, how much time do I have left?
21 minutes.
Oh, good.
21 minutes.
I may give a couple of those back. We'll see. Here's the allegation that Paxton directed employees at his office to act contrary to law by refusing to render a proper decision relating to a public information request for records held by the DPS, by issuing a decision involving another public information request, which is a mouthful, that was contrary to law and applicable legal precedent. That's the allegation. Here are the facts. Fact number one is that Paxton is the Attorney General. Paxton, as the Attorney General, can decide how his office responds to these inquiries. He's the Attorney General. Fact number two, Paxton did not order the release of the records. That's kind of been lost in the wash here. There's all these suggestions that Paxton ordered the release of the records that ostensibly were favorable to Nate Paul. No, he didn't. He did not order the release of those records, period, full stop. What he did was had his office take no position on whether or not the records should be released. That's a different color of horse. Fact number four, that no records were released to Nate Paul as a result of the actions of Ken Paxton. Let me repeat that. Nate Paul got not a single record based upon the action of Ken Paxton. Fact five, there were other records that were released to Nate Paul and his lawyers, but they had nothing to do with any action by Ken Paxton. You follow me? Other records were released, but not at Paxton's direction, suggestion, interference, what have you. Misuse of official information. The allegation, specifically Paxton improperly obtained access to information held by his office that had not been properly disclosed for the purpose of providing that information to the benefit of Nate Paul. That's the allegation. The facts are a little different. Fact number one, Paxton did not illegally access any records. Let me repeat that. Despite what the allegation is, he never accessed any record illegally. It didn't happen. As the Attorney General, Paxton had every right legally to access those records. Fact three, there's no evidence that Paxton copied those records. I'm kind of getting into the weeds with you here, but bear with me. There's a fellow named Vassar that you'll hear about. He had the file and is responsible for maintaining that file. He gave those files to Mr. Wicker, who Mr. Busby talked to you about. Mr. Wicker is an aide that works with Ken. Wicker says he was never asked to copy the file. I think the evidence is going to be pretty overwhelmingly that Ken Paxton may be more technologically challenged than me. So if anybody was going to copy those files, it wouldn't be Ken Paxton. I'm not even sure he had the code to the copy machine. Paxton gives the file back to Wicker after Wicker gave it to him. Wicker gives it back to Vassar. And there's no evidence that Paxton gave those documents to Mr. Paul. There's this big kerfuffle. And look, you're going to hear from a fellow by the name of Dave Maxwell. Dave is 6'6". Without the Stetson, you call Central Casting and ask them to send you a Texas Ranger, and by God, they send you Dave Maxwell. I'm a fan of Dave Maxwell, generally speaking, but Dave Maxwell did some things and said some things that weren't true. While he was being interviewed by the House, he said, and I quote, Ken Paxton gave the file to Drew Wicker, and he delivered it to Nate Paxton in an alley in the dark of the night. That's absolutely false. Maybe Dave was just comfortable in his own skin and thought he could stretch out his credibility. It's either a mistake or a lie. I don't care. Whatever it was wrong. That never happened. Months later, Wicker gives an envelope to Nate Paul, an envelope, but there's no evidence that that envelope contained these celebrated documents, and I suggest to you that these documents would have been several inches thick, not 2 or 3 pages, and it was, I'll skip past that, but at the time, or really after the time, when the Board of Managers is claiming that Nate Paul surreptitiously had these documents, his lawyers are still suing in court to get the documents. That makes no sense. Why would his lawyers still be pursuing civil remedies, which they're entitled to do, to get these documents if he already had the documents and if he'd gotten those documents from Ken Paxton? That is dumber than a bucket of hair. It makes no sense. They're just wrong. Maybe they had good intentions. Maybe this was their belief for the moment, but they're wrong. Fifth allegation, disregard of official duty, the engagement of Brandon Kamek. It is, while holding his office as Attorney General, Ken Paxton misused his official powers by violating the laws governing the appointment of prosecuting attorneys pro term or pro tem. We'll get into that. And Paxton engaged Brandon Kamek, a licensed attorney, to conduct an investigation into a baseless complaint. That's the allegation, during which Kamek issued more than 30 grand jury subpoenas in an effort to benefit Nate Paul, whatever. Here are the facts. Fact number one is Paxton has every legal right to hire Brandon Kamek. We're going to get into the why, but he's got that right under the government code. You're going to hear a bunch of kerfuffle about one of my favorite terms, the EAM, the Executive Action Memorandum. Sorry, but only in state government could we come up with a phrase like the Executive Action Memorandum. What it really is, it's policy. It's not the law. It's an internal policy within the Attorney General's office. It is not the law. Fact two, Kamek was not an attorney pro tem. Maybe that's a distinction without a difference, but that's what they've alleged. And you would think that these lawyers and the investigative committee and the committee are full of lawyers, most of which, or many of which, are ex-DAs. An attorney pro tem is appointed when the entire office has been disqualified. This had nothing to do with that. Brandon Kamek was hired, as the documents say, as an outside counsel, but they've alleged in their complaint he was an attorney pro tem. He was not. Fact three, a baseless complaint. Here's the funny thing about being a baseless complaint. They forgot to tell Brandon Kamek about that. And we've got a lot of people that have been hurt by these allegations and the investigations, and I guess it depends on your viewfinder on whose ox is getting gored and whether you like Brandon Kamek or not. He got absolutely skewered in the press. He was vilified by the press. He was just taken to the woodshed. He was beat like a rented mule by the press. And all that young man was trying to do was doing an investigation that the people who worked for Ken Paxton wouldn't do. And guess what? No one bothered to tell Mr. Kamek that it's a baseless investigation. In fact, he was told by Ken Paxton the same thing that Mark Penley was told by Ken Paxton, who parenthetically, I know and I like, but he didn't do anything. But more importantly, the direction given to Penley, the direction given to Kamek was the same. Find the truth. Let me repeat that. The direction that Paxton gave him in this corrupt, invasive, corrosive, bribery, kickback, horrible scheme, the direction he gave Mark Penley, who worked for him, was exactly the same direction he gave Brandon Kamek. Find the truth. We're going to impeach a sitting attorney general for giving the direction, find the truth. Not one person, not one piece of evidence will you hear where they say lie, where Ken Paxton told him to lie, cheat, steal, shade, do whatever it takes. That didn't happen. That didn't happen. And yet here we sit with 31 of you, with 15 of us and 15 or more of them. Here we sit when the allegation is it's corrupt, when the truth is, he said, go find the truth, for God's sakes. What are we doing here? Oh yeah, this baseless complaint that Mr. Murr, nice to meet you, sir, that Mr. Murr referred to, it wasn't a baseless complaint. The Travis County DA's office referred it to the AG's office, and ultimately a second one to Brandon Kamek. It may not be the greatest, sexiest complaint ever, but it wasn't baseless. Fact 4, no one bothered to tell Brandon Kamek. I think I've got a bit histrionical about that. And another one of my friends, Johnny Sutton, former United States attorney, worked under W., great lawyer, fine fella. But these same folks, the whistleblowers that are carping so much about Ken Paxton and going outside counsel and doing all these ultra-virus things when hiring another lawyer, they were trying to hire Johnny Sutton, who, last I checked, was an outside lawyer. Now, you got to be asking yourself, why is it that Paxton hired Kamek? Number one, Paxton believed in good faith that there had been misconduct. Number two, he asked his deputies to investigate it. His direction was simple: seek the truth. His staff did little to nothing in terms of an actual investigation. He asked again, nothing really happened. No one seemed to be interested in it at any of it. For 2 months, it just sat there. The one time where Ken Paxton comes to Mark Penley and says, hey man, I'd like you to look at this, he does nothing. He does absolutely nothing. Frustrated, he interviews outside lawyers and decided on Kamek. And again, he gave Kamek the same investigation or same instruction he gave Mark Penley: find the truth. At no time did Paxton ever seek to impede, impair, obstruct. Here's one of my favorite vignettes that you're going to see. Dave Maxwell, this 6'6" Texas Ranger, iconic figure. He's going to come in and say he was asked to participate in an illegal investigation. Really, Ranger? It's an illegal investigation, and on video, according to you, if your worldview is right, they ask you right there on videotape to participate in an illegal investigation, and you just sat there like a bump on the log. You didn't arrest anybody, you didn't make a note, you didn't cause the engine to file. It was illegal, and you were asked to participate in it, and literally, there you sat. This is our legendary one riot, one ranger in action, doing nothing? Really? Paxton just wanted it investigated. Mr. Busby stole a little bit of my thunder on these letterhead issues, but the point might be worth stating again. Who in the world do these people think they are? Honest to God, if your chief of staff came in and scraped your name off the letterhead and sent it out, how much longer do you think they'd be working for you? They wouldn't be, and they shouldn't be. Who in the world gave these people that idea? Who in the world told these people it was going to be okay? I bet you the evidence is no one. They took it upon themselves. They deputized themselves and were some sort of Power Ranger team where they could just do whatever they wanted, scrape Ken Paxton's name off the letterhead and send these letters out. Mr. Busby also talked to you about Michael Wynn's letter to Paxton, but I think it bears repeating. Under their worldview, Wynn, who represents Nate Paul, writes a letter to Ken Paxton, his supposed co-conspirator, threatens to sue his co-conspirator, threatens to sue the Office of the Attorney General, alleging false statements made by Ken Paxton to damaging Mr. Paul's reputation, claiming inappropriate coordination to undermine the investigation, alleging obstruction to prevent the Mitty Foundation investigation, literally bringing suit against one of his, what in the real world would be a co-conspirator. What's next? A hired hitman suing for breach of contract when he doesn't get paid for the kill? Are you kidding me? This makes absolutely no sense. None. And the reason it makes no sense is because there was no illegal relationship between Paxton and Paul. Look, I get it. I understand why there's some eye rolls about Paxton doing things that most of you would think, I don't know about that. I don't know about that. But here's why Paxton was a little different. These claims with Ken Paxton that Nate Paul was making, they resonated with him. I hear you. They very well may not have resonated with you, but I'll suggest to you, luckily, you haven't gone through what Ken Paxton has gone through for the last 8 years. Let me repeat that, 8 years. How do I know 8 years? Because I have been by his side on that Texas state securities fraud case. In that case, Paxton believed he had been the target of a wrongful prosecution. And here's why. Number one, it had been pending for 6 years at that point, back in 2020 when all the fur was hitting the fan.
Counselor, you have 4 minutes left.
Yes, sir, thank you. Number two, the judge that presided over the grand jury.
Excuse me, objection. I believe the court has said all 4 of those counts are out of this trial. He doesn't get to start talking about the merits of it.
I get to talk about his mindset.
My objection is he shouldn't be talking about this at all based on the court's ruling in the past.
I'm talking about his mindset.
We're not allowed to talk about it. How can he get up there in opening and give his version of it?
I'm talking about General Paxton's mindset as to why these claims were resonating with him.
All right. He started talking about a judge. He's talking about the facts. I object.
Sustained. Continue.
Let me put it this way. Ken Paxton was viewing things from a much different viewfinder than you or I might have been viewing those things through. And there's a reason why he was viewing things differently through a different viewfinder than you and I, because of what he had experienced. And it wasn't what you and I have experienced for the last 8 years. Let me get this through so I don't offend Mr. Hardin any further. Sorry, Rusty. Here's the difference between what the House did and what you have to do. What you cannot do is assume anything. What you must do is look through the viewfinder of beyond a reasonable doubt. Again, that is a much different process than what the House did. Is there proof beyond all reasonable doubt for you to convict Ken Paxton? And I suggest to you, it is crystal clear that there is not evidence beyond a reasonable doubt. I have one simple ask. Do the right thing. I think the senator that led us in prayer asked for the Lord's help on that. Literally, do the right thing. And the right thing is to vote not guilty. Thank y'all for your time.